Hi everyone, myself Arindam, and I'm a legal intern at LEXIS and Company. So today we'll be discussing on the very important doctrine related to the Contract Act, the doctrine of caveat emptor. I guess every one of you have one or the other day went to a shop and you have bought something with your whole consent, and then after buying that particular thing, when you come back home, you just think that the product is not worthy enough for your use or something like that, and you give back the product to the shop owner. So, do you think this is legal? Yes, if the owner is your friend, it's completely okay, he'll accept it. But if you go and file a case of something, a case of, let's say, forgery or something, you must buy the product. Once you buy the product, you must see that all the necessities that you need in the product are fulfilled. Let's say once you buy the product and you are satisfied with the product, and after buying, when you come back home, you just think that the product was better. This is not applicable. This is not actually, not very correct. So the doctrine of caveat emptor says that this lays down actually an essential precept that a customer will be privy to his obligations to test the quality and sustainability of the product that he is buying, and as soon as he is satisfied, he shall not have any right to reject the product. Doctrine is primarily based on a presumption that a purchaser possesses capabilities and judgments to be confident on the quality of the product. Thus, the supplier need to now no longer be held responsible if the product does not stay as much as the potential or the purchaser's potential. A commercial transaction includes two parties, there is a supplier and a customer. Each needs to take care of each other to shield their personal hobbies and rights, right? When someone is shopping for items, he needs to look at them very well, and the vendor is under no responsibility to reveal the complete truth about his goods. He is here to sell a product, right? You, as a customer, should understand your needs and also understand what are the necessities that the product requires to be or to satisfy your good. So the meaning of the maxim caveat emptor is let the buyer be aware. And with the meaning, I guess every one of you can understand that this means that the customer has an obligation closer to supplier to offer him information about his requirement, and the vendor will deliver and according to his requirements. So the concept of caveat emptor applies in case of buys of precise items when whether he can use his personal judgment and should purchase items in his personal obligations. For example, purchase of a guitar. I went to a shop and purchased a guitar, and the next day I went go to the the guy who sold me the guitar, and I say him that this is not a good guitar, I need another one. This is no, I show him okay grounds, right grounds, but then he'll ask me that when you bought the product, you didn't see that you had such a mistake or such a error in the guitar chords, then why are you coming now? He may ask me, and I have no answer to that. So, but with every rule, there comes an exceptions. So, the exception to the rules of caveat emptor are when the seller makes a false representation and the buyer relies on representation. This is first exception to the doctrine of caveat emptor. The second one is when the seller actively conceals a defect in the good so that no reasonable or on a reasonable examination, the same could not be discovered. Where the goods are purchased by description and they do not correspond with the description, where the goods are purchased by description from a seller who deals in goods of that particular description and goods are not of a mercantile quality, when the goods are purchased by sample and the bulk does not correspond with the sample, and where the goods are purchased by sample as well as by description, but and also the bulk does not correspond both with the sample and with the description. So there are two very important case laws. Okay, so we'll be discussing on that too. So the first case law that we'll be discussing is on Wards versus Hobbs. So that was the case happened around 1878. In the House of Lords held that a vendor cannot be expected to use artifice or disguise to conceal the defects in the products sold, since that would amount to fraud on the vendee. Yet the doctrine of caveat emptor does not impose duties on vendor to disclose each and every defect in the product. The caveat emptor imposes such obligations on vendee to use care and skill while purchasing such products. In Wallace versus Russell, this happened in around 1902. So the Court of Appeal explained the scope of caveat emptor. Caveat emptor does not mean in law that the buyer must take a chance. It means he must take care. It applies to the purchase of a specified thing, that is a horse or a picture, upon which the buyer can and usually does exercise his own judgment. It applies also whenever the buyer voluntarily chooses what he buys. It applies also wherever usage or otherwise in terms of a contract that the buyer shall not rely on the skill or judgment of the seller. Thank you. Please do like and subscribe our channel.